Good evening. We will start in just 1 minute. Thank you for joining us. Welcome, everyone. Very pleased to have you join us for this webinar. In this webinar series, we have had and will have some of our friends from foreign law firms around the world. Tonight, I am going to share some thoughts or some know-how and training materials on a very important topic, in my view. This relates to the growing trend of Chinese manufacturing companies moving their factories overseas. And as lawyers, whether we're in-house lawyers or we're law firm lawyers, we need to better understand all of the related issues. So tonight, I'm going to be sharing some of the same content that was included in our online training course for last year, the Next Gen Lawyers training program course. So some of you who participated in that course will see that there's some similar material or some of the same base content. But we've added some material up front, and we're going to emphasize more of the structuring aspects and more of the commercial aspects, and probably will not spend as much time on the technical details of drafting these clauses or these agreements. So with that, let's get started. So first of all, we want to consider, why is it that some manufacturing is moving outside of China to overseas locations? One of the reasons we have to ask this question is that China now clearly has the world's best and most comprehensive integrated supply chain. In fact, as we talk to foreign companies as well as Chinese companies, everyone acknowledges that the domestic supply chain is superior in China to anything anywhere else in the world. And so while we do see that there has been a lot of talk, particularly from the United States and some from Europe, about decoupling, in the last year or so, we see that even the US and Europe, these government authorities have recognized that it's impossible to completely decouple from China because the supply chain here is so strong. And now when we talk to Chinese companies, and they are thinking about moving some of their operations overseas, they also have very serious concerns about leaving or separating from the superior integrated supply chain system that exists here in China. But yet we see this very important trend. So why is it that Chinese companies are moving more manufacturing operations, more factories overseas? Now, one reason is to have access to lower cost labor. And we do see that. Southeast Asia, some areas of Africa, other areas of the world where labor costs are lower. That's a very important trend and contributor to this overall trend. But another major part is market access. Now, market access has a couple different aspects. One is, in order to sell more effectively in a particular target market, you find that you sometimes need to be manufacturing there so that you have faster turnaround time and are able to reflect the requirements of that market because you're in that market. And sometimes it's because you want to develop more goodwill. I'll talk about that in just a minute. So these are two of the main types of motivations. But in this market access aspect, there's another part, and that is to avoid import restrictions or restrictions on market access. So we'll see that as we go forward as well. So, for example, where are Chinese factories moving? Well, we can see on the top line, we have Asian countries. So we have Vietnam, we have Indonesia, we have Thailand, we have India. Now, a lot of those areas will have much lower manufacturing costs. And then we go down to Central and Eastern Europe, and we have Hungary, Romania, we have Poland. And then the last one is Mexico. Now, there are some lower costs in all of these jurisdictions, but there's another aspect that's critically important, and that is that when manufacturing is done in some of these countries, it opens up market access. For example, Mexico opens up access to the US market. Vietnam, same thing. When you look at Hungary or Romania or these other Central Eastern European countries, those countries can help unlock the European Union countries and that market. So we see that there is this combination of factors. Now, again, sometimes direct exports from China directly into the US or some other markets may create some or may encounter some challenges and problems. And so therefore, by moving manufacturing to one of these other countries, you're able to market or sell directly into the target markets. So these are all factors that we have to take into account. Now, I want to step back and provide a broader overview as well. And I want to look again at what happened with Japanese manufacturing companies who had a much earlier start, who started 30 or 40 years earlier than most Chinese companies. If you look at, and the same thing would be true for Korean manufacturers. And let's take automobile manufacturers, because of course now with Chinese leadership in EV manufacturing, we can see that by looking at the Korean and the Japanese automobile manufacturers and see what they did starting many years ago, we can see some natural trends. So, for example, we saw that the Japanese automakers, initially they manufactured solely in Japan, and then they sold directly by export into the US. Now, there was a lot of mistrust on the part of US consumers. They didn't fully accept these Japanese automobiles at first. And in fact, since I was alive during that period of time and remember it well, my parents bought a Datsun, as it was then called, now Nissan. And we considered that to be a very inexpensive but not high quality automobile. Over time, the product quality improved, the brand value improved, the level of acceptance by American consumers increased, but there was still some resistance. The Japanese and later the Korean automobile manufacturers could not fully penetrate the US market because there was this concern that these were imported, that the Japanese automobile manufacturers were accessing and taking advantage of the large US consumer market for automobiles, but they were not participating in the economy. They were not contributing to the economy. So there was sometimes regulatory pressures, but there were certainly consumer pressures to have manufacturing moved to the United States. So we see that significant volume of Japanese automobiles sold in the US are now made in the US. And that has helped improve the overall level of acceptance. Now let's take another example. We see that Chinese EVs are able to now achieve a very competitive price point, and the quality is quite high. And so therefore, we had former President Donald Trump, and now candidate again to be president, who made a comment a month ago that was widely reported in the US media, but actually it was only partially reported. And that was that he said that if the Chinese automobile manufacturers, if the Chinese EV manufacturers move their production to Mexico, even though there is the North American trade agreement that would allow Mexican goods to be able to come in more easily into the US, he was still going to impose a 100% tariff on all of those Chinese EVs manufactured in Mexico. But he said, if Chinese manufacturers invested in the US and built a manufacturing facility, a factory in the US, then he, if he were president, would welcome them. You see, this is the type of normal response that many countries will have to foreign manufacturers. Previously, we saw it with Japanese manufacturers and Korean. Now we see it with Chinese manufacturers. So these are all part of how we evaluate this whole trend towards moving manufacturing outside of China to the rest of the world. But again, we have to remember that the most complete and robust supply chain exists here in China. So these are all things that have to be balanced. Now, as we, as lawyers, work with our clients, whether we are the in-house legal team working with management or we are the outside legal team working with the client, and they are planning to make this move, we have to understand the broader political, geopolitical, and economic environment, but we also have to understand the transaction structuring elements. We have to understand what are the different aspects of this type of transaction where we as lawyers have to help the client protect its interests. So here on this slide, I've simply outlined the main elements of the transaction structure for moving factory production outside of China. So we start with the China factory. It has everything it needs. It's part of this very robust China supply chain system, ecosystem. And then it's going to put a factory somewhere else in the world. In ASEAN, if you're doing EVs, Thailand is a very good choice. Vietnam maybe as well. Mexico, we see Hungary attracting a lot of investment from Chinese manufacturers for access to the EU market. You have to then think, okay, you have that factory. How do you structure the relationship between the China parent company or home company with the local factory in the overseas jurisdiction? And there are several elements, and this is simplifying it, but I outlined these four elements. There's manufacturing technology license aspect. There's component supply. There are trademark license issues. And then there are marketing rights. So let's look at each of those at a very high level. What are the issues? What are the risks? What should you be paying attention to in connection with manufacturing technology license? First of all, you have to consider, where are your risks? You own the factory. Well, maybe you don't own it 100%. What if you, by choice, have a local partner, or by law, you are required to have a local partner? For example, in international automobile manufacturing companies in China, they are all joint ventures. So if you go to another country, you have to understand, are you required to have a local partner? Well, even if you don't have a local partner, even if you own 100% of that local factory in the overseas jurisdiction, you still have your local employees. Everything about your technology can be at risk vis-a-vis or in respect of your cooperation with your partner, local partner, and with your local employees. You also have to be thinking about China export rules. Now we do not have the simple type of manufacturing technology that we previously had because China is also a leader in automated robotics, manufacturing robotics. And there's going to be a lot of AI involved, algorithms, other types of cutting edge, fourth industrial revolution type technology. And so there may be a requirement that there be some sort of export license to export that technology to the foreign country. And then you have to consider the form of the technology rights. And we're going to talk about this a little bit more as we go forward here. But you have to understand, what is the form of the technology? Is it know-how? That's the highest risk. It can be the most valuable because you have this know-how and you don't have to disclose it. In fact, you do not disclose it to anyone else. And so you have an advantage by having proprietary technical know-how that nobody else has, but it's hard to protect. It's easy if you don't take the correct measures for others to access it, including your partner, including your employees in the foreign jurisdiction. If it's patents, then you have to go through all of the efforts to make sure that your patents are enforceable, and they're enforceable only for a certain period of time. So there are all the strategies about updating and extending the patents so that you are always using new technology, new patented technology that is still under protection from patent filings. Then you have software, you have technical assistance, you have other aspects. So you have to understand, what form does the technology take? So this is a broad overview of how we approach this aspect. Now remember, even though it's your factory, you have to consider that there are many others in that environment, in that ecosystem, in the foreign country, maybe component suppliers, maybe third parties, maybe employees, maybe partners. All of these may put your technology rights at risk. So you have to think about it in those ways. And you'll see some of this also be addressed through some of these other aspects. So let's go to the next part, component supply. Now, one thing we may consider is that there are some aspects of the technology or the manufacturing process that will still be done here in China. Sometimes that's because the overall supply chain ecosystem is more comprehensive here. You can achieve higher quality at lower cost here. And so therefore you may be taking the main big pieces of the components already manufactured here in China, shipping them to the foreign jurisdiction and having the factory in the foreign location simply do assembly and test, 组装. So they might be focused on that aspect only. That's something that you have to decide with the client. It's a business decision, but it's also a legal structuring decision, because you want to try to protect some of the core technology by never allowing the employees or the partners or the suppliers in the local jurisdiction overseas to even know what it is. It's built into the product, into the components. It's a black box. But then you have the other issue of whether there are local content requirements in the local jurisdiction. So for example, we know that in the US, that for batteries, for EVs, for other types of new energy vehicles, that there are certain requirements on how much local content is required in order for them to be sold in the US or to be entitled to receive certain subsidies and support. That's typical in a lot of different countries. So you have to understand what are the local content requirements, and then you have to balance that against all of the other issues we're talking about. But notice how component supply is another important way to protect technology rights. So now we go to trademark license. So trademark relates to quality control. When you have quality control as a main focus, then you have to have inspection rights. Even if you own 100% of the factory, there has to be a system whereby people from the home office go and inspect and make sure that all of these systems, the manufacturing protocols, are all implemented in the right way, because you have to ensure the highest standard of quality in every respect, while at the same time protecting your core technology. So when we talk about trademark, we're thinking about quality control, because the value of your trademark depends on the quality of the products. So for example, as I said, 40 years ago, 50 years ago, when Japanese automobiles first entered the US market, they were considered to be very low quality. And therefore, the brand value was also correspondingly low. Now, I will also tell you, when I first graduated from law school, for the first period of time, I was working on a litigation team where they were involved in tort claims or accident claims. And we were bringing a major litigation action against one of the largest Japanese automobile manufacturers because some of the passengers had been injured in an accident in those automobiles. And it was determined by the court that the product quality of the Japanese automobiles were substandard, and that the Japanese manufacturers knew that it was substandard, and therefore they had to pay millions of dollars to compensate this person who was injured. And this, as I recall, was a class action, which meant it wasn't just one person who was injured, it was on behalf of everyone who had suffered similar injuries. So that was a very large award. So you can see that quality control is not just related to brand value and how much you can charge for your product, but it also is something that protects against liability or potential liability. But when we talk about trademarks, we also have to think, do we need a new trademark for a new market? This is something that many Chinese companies need to think about. If you have a Chinese company with a Chinese brand, well, then when it goes overseas, maybe that brand is not easy to pronounce for a foreign consumer. Or, on the other hand, maybe it's obvious from the name, from the trademark, that it is a Chinese company product. And maybe you don't want the consumer to immediately understand that this is a Chinese product. Maybe the market will accept the product more easily or more readily if they don't know that it's a Chinese product. Maybe they will think that if some product, but they don't know where it's originally from, maybe they will have higher level of acceptance than if it's clearly a Chinese brand. These are all things that have to be considered. So then we get to this last element, and that's on marketing rights. Now, sometimes if you own 100% of the manufacturing facility, then this is not an issue. This is an internal coordination matter. Well, there are still some issues. Even if you own 100%, you have to decide, given the type of product and the type of market, do you want to build up your own sales team to sell the product in that market? Or is the production all to be repurchased by the Chinese parent company and sold elsewhere in the world through its own distribution channels? Or will you use third-party sales channels to make the sales? In many cases, you will want to develop local sales channel capabilities. So these, again, are all the different aspects. So you have to think about this concept of moving manufacturing overseas as not just a simple exercise. You are moving an entire ecosystem. Sometimes with component supply, you're taking the core components, making them here in China and shipping them as a black box to the local jurisdiction. And there you are procuring some smaller items that may be easy to procure there in that market, and then to have the final assembly. But you have to think about sales, procurement, licensing, manufacturing, employee relations, protecting your IP, protecting the product quality, protecting your liability for product quality issues. So this is the broader picture. So now as we move forward, I'm going to go through again some of the materials that we had included as part of our training program last year. But we're going to focus more on these big picture elements. So I hope you can start to see this. Now, stepping back, when we talk about a manufacturing license, we can really talk about three different categories. What I'm referring to as a manufacturing license, that's what I've been describing, and that's what we will focus on. But we also want to compare it against an ODM and an OEM agreement. So let's look at these very quickly. So I am describing so far, and I will continue in tonight's program, to talk about a manufacturing license, which I believe is suitable for license of technology to an offshore subsidiary. And there we have the manufacturing technology, IP, and the licensor, meaning the Chinese company as licensor, its trademark will be licensed to the offshore subsidiary. So I see this manufacturing license as the preferred approach or structure for this type of foreign factory arrangement. Now, ODM and OEM are more for dealing with third parties. Now, I have to say it is possible in a manufacturing license to still use that structure with a third party. But very commonly with a third party, you would do an ODM agreement or an OEM agreement. Now, I'm not going to go into significant detail on the distinctions here. I will just note that ODM means that the factory is already manufacturing a certain category of product, and then the buyer says, well, I would like to have that product manufactured for me using my brand name, and then I can sell it. But what it means is that the ODM factory party, they already have the product. They already know how to do it. They are doing it, and they're just going to make some minor modifications to their existing product design, and they will add your label to it. Whereas an OEM is different, because that's where the buyer goes to the factory and says, I want you to manufacture a certain product for me, and I will tell you all the specifications. I will give you the design. I will give you the tools or instruct you to procure the tools, and I will share with you the manufacturing technology that's specific to this product, and you will make it for me. It's highly customized, and therefore the intellectual property belongs to me as the buyer, not to the factory. And then the buyer's trademark is applied. Okay, that's just general high-level overview. Obviously, we could go into a lot more detail in our course. We did. But now I'm just going to ask a simple question here. We'll give you 1 minute. Just think about this. Manufacturing license, ODM agreement, OEM agreement. This illustrates a principle. Which party should draft the agreement? Okay, think about this for just a minute. What's the principle? Okay, we'll talk about the principle after we share the answers. But think about this. Who should draft the license agreement? Should it be the licensor or the licensee? That's the parent or the subsidiary in our case. For the ODM agreement, should be the buyer or the factory. The factory already knows how to manufacture the product. It already has the design, has all the capability. Then the OEM, there we have the buyer is going to tell the factory how to do it. Okay, so let's look at this. Did you already make a note of your suggested responses? Okay, let's look here. Okay, so here, the manufacturing license typically should be drafted by the licensor. The licensor has the most at risk. The licensor needs to protect its technology, has to protect product quality. All of the risks are on the licensor, so the licensor should draft in order to protect itself. The ODM agreement, the factory usually is going to draft the agreement because it's already manufacturing this product. It already has all of the tools, the technology, et cetera. It's going to make minor adjustments and put your name on it. So it will have its own template for the products, and it will have its own template for the agreement. The OEM agreement, on the other hand, should be driven by or controlled by the buyer, not the factory. The buyer is telling the factory what to do. The buyer wants to make sure that the factory achieves certain levels of specifications and unique design elements in many cases. So that's how we would approach this. I hope that's helpful. Okay, now when we look at a manufacturing license, I mentioned this earlier, we have to identify what are the different elements of technology or intellectual property rights that can be involved. Now here I've identified these four main categories. We've talked about patents, we've talked a little bit about know-how, but there's also almost always going to be software, and then I've mentioned trademarks. Now we could add something else here, and that's technical assistance or technical training. That goes along with know-how, but it can also go along with patents. And in fact, many times you have patents and then you have know-how relating to the patents. And then you have software, which usually, or in many cases, has been developed by the licensor, or it may have been acquired from third parties. So that's different as well. So the software license aspects will differ depending on whether this is self-developed by the licensor, the Chinese company, or it's been procured and applied by the Chinese company from a third party. So let's look at some of these aspects. Now, this is a general overview. I refer to this manufacturing license as a manufacturing technology license agreement. And that's an agreement between the licensor, which is a manufacturer, in this case, a Chinese company, which holds title to the manufacturing technology to be licensed, or an authorized sub-licensor. So that could mean maybe the Chinese company didn't develop this technology itself, but it had licensed it from a third party and then added some of its own. So maybe a combination. And then it licenses all of this package to the subsidiary. In this case, we will call it a subsidiary. So this is the licensee, which is a manufacturer which seeks to use the manufacturing technology. Now, let me stop here again. You may think if I as the Chinese company own 100% of the foreign subsidiary, I don't need to worry about this. Actually, I think it's absolutely critical that you always have a proper comprehensive license agreement for this technology between the Chinese parent company and the overseas subsidiary. And why is that? That is so that it's clear what are the limitations on the access and use of that technology by the employees of the foreign subsidiary. You need to make sure that local management is fully and clearly instructed on what it can and cannot do, and that the employees also know what they can do and what they cannot do with this licensed technology. This is very valuable to assert control and protections around or regarding this technology. So you have a license, even if you're not going to get paid a license fee. You have the license so that you can impose a comprehensive set of restrictions on the use of that. And then the foreign subsidiary signs employment agreements with all of its employees that then mirrors or reflects those same restrictions. And many times you'll have to build in systems, particularly with respect to know-how, to make sure that only authorized personnel have access to the know-how. So again, so we have the licensee grants a license or a right to use the manufacturing technology, which can be patents or know-how, and you can get a fixed fee or a royalty. And then there can also be technical assistance and training, and also there can be trademarks and operating software. There can be manufacturing software and operating software. So I hope you're starting to understand that this can be somewhat complex, which makes it very interesting. But again, we have a purpose for every aspect here. We want to control all of these intellectual property rights to make sure that there is no inadvertent leakage to other parties. And always think of the employees in the foreign jurisdiction as third parties. You have to impose restrictions on them. The same thing with your suppliers and your partners. Okay, so these are some of the questions that we think are important that you should ask before you start drafting this type of manufacturing license agreement. I'm not going to go through all of these. Actually, in our online training course, we spend more time on this. We have only enough time this evening to have a short overview, but you can see that here we have listed all of these different commercial questions. There are no legal questions here. Well, we may have legal questions, but they're not on this list. Now, when we are drafting an agreement, we have to think like a business person. We have to help our business clients walk us through the overall structure and the elements of this transaction so that we can know how to draft this type of manufacturing license agreement. And again, our purpose is to help the licensor, in this case, the Chinese company, achieve a high level of control in respect of product quality and market access, in each case subject to the requirements of law. Those are the legal questions, which we've not included here. Now, this list of questions is something that we include in our docQbot, 合同, list of introductory materials relating to the a manufacturing license. And we do this with all of our agreements, so you can start thinking right from the beginning. What are the questions I should ask? What is the information I need so that I can draft the agreement to include all of the relevant terms? Okay, now here's an overview of how we have structured our manufacturing license. Obviously, we do it in English and Chinese. It's possible to have slightly different order of these clauses. It's also possible to have some of the content from the annexes put into the main body, but I think this is a very useful way to structure the agreement. But this gives you an idea of what types of elements you should be expecting to be included. Now notice that in this version, this is more than 20 pages. This should be in the bilingual version. And then you also have the additional pages for the annexes. So this is not a short agreement. We have, when we draft this, we have simplified this already. This is not as lengthy or convoluted as many US lawyers would draft. And it's already bilingual. But we cover all of the key elements. And we make this fit together with these questions that we just asked. So now let's look at a couple of these main provisions. We may not have time to go through all of these, but I want to hit some highlights. So even for these, where we do go through it, we'll just go through it at a very high level. So for example, the core clause in any license agreement is the license grant clause. You always have to look at this very, very carefully. I remember probably 20 years ago when I started doing training here in China. I was cooperating with the 全国律协. And I remember that we talked about these license agreements and we used a similar template, now updated. We used a similar template, and I had the lawyers who were present and participating in the course. I had them look just at this license grant clause. And I gave them 15 to 20 minutes to make a list of all of the things that they might want to negotiate or possibly revise if they were the licensee. Now, again, this was, as we said, the license agreement typically will be drafted by the licensor. So if you're the licensee, what are the elements that you might want to push back on? Or you might want to make some revisions, or you might want to understand or clarify certain things. Well, I gave the lawyers who were participating in that, at that time, we had 300 or 400 lawyers in the room, all intently reviewing this clause. And notice it looks very simple, doesn't it? Actually, every word is critical. So after giving all of the lawyers in attendance 15, 20 minutes to review and make some notes, I probably spent 1 hour, maybe 2 hours, going through word by word, line by line. And that's because every word is critical here. You have to already know what things are not negotiable and what things are negotiable, what things can change depending on the circumstances. So if you have a subsidiary and you have a local partner, that changes the overall dynamics. Are they majority? Are you 50-50? Are they minority? These are all things you have to think of. Now, we're just going to look at a couple of points here. And again, we aren't going in depth in tonight's webinar. This is to give you a general overview. But if you look at patents, then you can see the definition of patents is critical. Now, here we have patents and we have patent rights, and those are both key terms. And then you have your annex with the list of the licensor patents. Now, you may think that there's only one way to draft this, and there are some common ways to approach the drafting of these definitions, but you have to read it very, very carefully. And then you have to make sure that the annex or the list of licensor patents is set out in a proper format so that it's very clear and you're fully protected. So now let's look at technical information and tools. Now, technical information relates to know-how, as you see here, and tools is also another form of know-how. Now, when we talk about modern manufacturing, more robotics, more automation, then the tools are even more important. So in the past, it may have been machine tools, or it may have been certain assembly tools. But now we have much more highly sophisticated tools. So you have to have these clearly defined. And again, we have this as an annex. Now, your technical information description has to be sufficient, but not disclose too much, because the more you disclose, the less it's protected. So this is a very critical balance. Know-how is harder to protect. And again, with know-how, we don't have it here. You also need to look at, is there a way to only permit certain authorized people to have access to certain aspects of the technical information. So, in other words, you might have technical information that covers 10 different elements, and maybe you ensure that no one, or maybe only one or two people, have access to all 10 elements. And you have only different people in different work units within the factory who have access to different parts of that know-how, so that no one person can pull everything together and walk away with it. These are all things that you think about. There's the black box, and then there's how you manage the technical information. So there's the agreement, but then there's the manner of implementing the agreement, and the agreement has to spell that out. So you see, I have that down below. And I would suggest now, you should add restrictions on access to know-how. Okay, now we have the question of improvements. Now, I'm not going to go into great detail here. Here we have something about licensor improvements. So that means the parent company, in this case in China, is continually upgrading. And so therefore, there should be some requirement that there will be upgrading of the technical information to reflect improvements. Okay, then we have, though, what about the other way? So in our course, we had an interview with a good friend of mine who's a partner, an IP partner in Thailand, in the leading law firm in ASEAN. And he has had a lot of experience working with manufacturing licenses involving automobile manufacturing in Thailand, because that's an area of competence in Thailand. And so it's understood that Thai engineers in this process will come up with some improvements. And therefore, you have to know, how do you treat that? Now, you also have to look at the law, because sometimes the law will tell you, impose certain restrictions on having the licensor just take all of the improvements back from the licensee. These are things you need to look at. There are also considerations about the employees and what rights do they have to their inventions in an individual capacity. So you have to go through all of these types of issues. And you also have to think in broader terms. As a minimum, as the Chinese parent company, as the licensor, if the licensee, if your factory overseas makes some improvements, at a minimum, you want to have a grant back or a license back, so that the subsidiary licenses to the parent all of these improvements. So then the parent company can use those improvements here in China and the rest of the world. These are very complicated issues. I'm just raising this as something that you should keep in mind. Okay, so now we have the exclusivity issue. The license can be granted on an exclusive or non-exclusive basis. Now, under an exclusive license arrangement, subject to the specific terms agreed by the parties, the licensor will not be permitted to appoint any other licensee to manufacture and sell the product in the territory, or to directly market and sell the licensed products in the territory. So these are things you have to understand. There are different ways that you can structure this. Is the local manufacturing entity to have the sole and exclusive right to manufacture, but also to sell? This is very critical. So then you have to think about minimum performance requirements. This is more important when you have a partner and you have to do a joint venture. But these are all things that you need to consider. So as you can see, this is where our skill as lawyers reflects not only our ability to draft, but also to understand the commercial arrangements. Okay, now license fees, because of time, I won't go into any great detail. I will just say that sometimes you have an upfront license fee. Sometimes you have a continuing royalty based on net sales. And sometimes you have a combination. And sometimes you don't have any because you are only licensing in order to impose restrictions on your wholly owned subsidiary. You'll also have to think about the license fee, how much that is, and whether that will be subject to scrutiny for the amount of tax. If you look in India right now, what we see is that there are limits on Chinese ownership of certain types of businesses in India. And one way to get around that is you say, okay, well, maybe I only own 10%, but I will license all of my know-how and my technology to the Indian subsidiary, and I will provide technical assistance and other services. And therefore, the bulk of the revenue from the sales in India actually does not stay in India, but is paid out to the Chinese parent company or minority parent company in the form of license fees and service fees. Well, now we see that in India, they are reviewing those types of arrangements and sometimes imposing very high taxes on those license fees and those service fees. In any event, license fees and service fees are usually taxed at a different rate than the sale of components or the payment of dividends. These are all things that you have to think about comprehensively. Okay, now, technical assistance. This is something where this can be something that supplements the know-how. You provide technical information and you provide technical assistance. But this is also another way to enforce product quality. You have people from the home office who go to the foreign country to inspect, to train, and to observe. So these are all things that you need to look at. So here are some sample clauses on technical assistance and training. Then on trademarks, always have to be very careful to have very technically detailed clauses on trademarks, even if it's your own subsidiary. Now, you can shorten them a bit if it's your 100% owned subsidiary, but you need to have contractual rights here as well for additional protections, again, because then you can reflect those in your employment agreements with your employees. Okay, so again, these are components. This is quality control. You have some components that come from the licensor. Those can include black box technology, but then you have some components that are procured locally from third parties, and there are different levels of control that you can impose on that. And then there's subcontractors. It's very important to be able to control the overseas factory's use of subcontractors, because what about transferring or making available some of the technical information? That's know-how. You have to protect your know-how. So also with all of these arrangements with third-party component suppliers, with subcontractors, you have to have the licensee, even if it's your own majority-owned subsidiary, you have to have joint liability and step-in rights, which we do not have time to talk about here. But again, I'm trying to describe this in overall terms so that you can see the relationships here and know that we have the know-how, including in the Hetong database, but also in our training. And then there's technical information disclosure, as I say. So this is actually very critical. So important that you have very clear process for what can be disclosed to third parties so that they can either supply components or that they can provide subcontracting services. This is all part about protecting the intellectual property rights of the Chinese parent company. So the last part here, I would say on quality control would be approved facilities. This is something where you can go in and inspect. Now, remember, if you are in a situation where by law, as in India, you can only own a minority share, a very small minority share, you need to have some of these other types of rights so that you can ensure product quality, because you can't do it through ownership. But even if you own majority or 100%, you should have some concepts about how to ensure that the parent company licensor, is actually able to ensure quality control. Now, here's my last slide that I do in the training course. And I say, here are a lot of other standard provisions in a manufacturing license agreement. And the question is, are there any unique or special revisions or amendments that need to be made to these terms in connection with a manufacturing license agreement? So what do you think? Now, those who took the course, they know that in almost every case in these agreements, we find that term and termination provisions have to be dealt with in a manner that reflects the specific conditions of that type of transaction. But I'll just give you some examples of other types of changes. So, for example, software license. Well, you may have not just software, it could be operating software for the product, it could be manufacturing software for the manufacturing process, it could be firmware that's embedded into the hardware, and it could be third-party software. And in each case, you want to ensure there's no source code accessibility. Then term and termination, where I say there's always going to be something unique to every type of transaction. The patent license has to expire when the patent expires. That's a critical, basic point, but one that's easy to overlook. And then how do you handle existing orders at the time of termination? That also is similar to distribution agreements, etc. So one of the things we tried to demonstrate through our training course and through our know-how, Hotong, is that there are common elements to most contracts. So we have some standard sample clauses, sample structures. But then even in those standard clauses, in each type of transaction agreement, there will be some modifications. And you have to understand those differences. There's a difference when you are party A as opposed to party B. We have all of that built into our know-how system. All of the things you saw here in terms of the general description of the types of agreements, of the questions that you should be asking before you start to draft or before you start to review, but also all of the clauses and the different considerations. All of this is available in our Hotong database in English and in Chinese. And so we see this not just for when you're drafting, but we see this for when you're reviewing, or perhaps you're an in-house counsel and you are have drafted your contract based on your in-house template and you sent it to the other side, but they have made some revisions and they have suggested some revisions that are outside of what's included in your set of templates. And you want to know, well, can I accept that? Is their suggested revision acceptable? Or is it acceptable in part? What should I understand? Why would they be proposing that? What are the normal responses that we might have in our situation? There's always buyer versus seller, licensor versus licensee. There are all these typical concepts and arrangements. And so while there are unique circumstances to every deal, probably 80 to 90% of the time, the issues that are being negotiated are fairly typical for that type of transaction. And there are different combinations. The buy side and the sell side will often have the same types of requests and responses. But in different circumstances, you would say yes, and in other circumstances, you would say no. So you have to understand what those circumstances are. All of this is part of our effort to promote 涉外法治建设. It's to help Chinese lawyers understand the framework, but also the details. To understand the business context, but also how to look at these things as a lawyer. So that's the value of our knowledge, know-how database. Now, last thing for tonight, I want to remind you or let you know that at the end of next month, we have an outstanding training program. This is in-person training program. And as you can see, we have foreign experts from around the world coming to do an in-person training program on compliance management. You see that we have people from the US, from UK, from Germany, from the Netherlands, from India, from Japan, from Russia. So you can see that we have a very comprehensive coverage of all of the key issues relating to compliance management. This is the number one issue and concern for all Chinese companies that have global operations. And so we have assembled this outstanding faculty to come so you can meet them in person. It's in Hangzhou at the end of next month. We have a QR code here. Please scan, find out more information. We enjoy having you come. Look forward to seeing you there. So now we'll see, do we have any questions? So I need to see if there's, maybe my colleagues can send me a chat if there's something where there's a question, or if there's someone who wants to, if there's some other way to raise a question. Okay, one moment. I think we have something here. Just a minute. Just need to pull it up. Okay. All right. So the question, if I understand it, okay. So it seems that, okay. All right. So this is a comment, actually. I don't think it's a question. It's a comment. It goes back to the question that I raised up front, where I said, who takes the lead in drafting? And the comment was that it seems that it depends on who has more power or control in a collaboration. And that's true, but that's not exactly the point that I was trying to make. I was trying to emphasize that whichever party has the most at risk should be the party that drafts the agreement, to ensure that to the fullest extent possible, the risks faced by that party can be properly controlled in a balanced and fair way. So here's an easy example, a non-disclosure agreement. If it's a unilateral non-disclosure agreement, meaning only one side is the disclosing party and the other side is the receiving party, then the disclosing party drafts the NDA, because the disclosing party has more at risk. It is providing confidential information to the receiving party. And so the disclosing party it's reasonable for the disclosing party to have the right to provide the full range of protections for that confidential information. Same thing with a license. The licensor is holding all this valuable technology know-how, if that's what we're dealing with, or trademarks or software or other, and therefore it should have the right to draft the license agreement to protect its valuable core intellectual property rights. That's the right balance because of the transaction nature. Now, it's also possible that you may have, for example, we just did a deal recently where it was a smaller technology startup company in China. It developed some very interesting technology. And then one of the big US-based technology companies wanted to acquire that technology. Now, it was done through some various structures, but you have a small company, the startup, that is the licensor or the assignor, depending on the nature and structure of the transaction. But it was a big, huge company that had much more bargaining power, that was the licensee or assignee. And in that case, the bigger company would draft the contract. That's the way it would work. But if it's roughly equal in terms of bargaining power, then the party with more at risk should draft. So those are both things you have to balance as you are looking at who drafts the agreement. So I hope that was helpful. All right, I think that's the only question we had. Again, today was a general overview, more business elements, and trying to understand how we should be thinking commercially as lawyers. More of the technical drafting was covered in our training course and is covered in our know-how. So with that, we'll say goodnight, and we'll look forward to seeing you for our next webinar, which will come up next week. We have 2 already in planning. More information to come. They're going to be outstanding. Looking forward to seeing you again next time. Thanks.